Let me check. 19 is what? 1956, 16, 4, 17, 5, 18, 6, 19, 7, 756.
From that, that way you go to the attribute.
Yes, so general. You know, he's talking of the those from Judaism. Okay,
Oh yeah,
Good evening, everyone. Good evening.
Good evening, sir.
Yeah.
Good evening, sir.
Good evening, sir.
Now, good evening. So I only have 20 people here, which is very bad. Now, I will intend to start this class by latest 8:10. So whoever is not here, they can join later. But I'm not going to wait for too long, so that already we are going to finish fairly late in the night. So we need to start early too. So I hope others join early enough. Mm.
There's no water here. I can't remember the last time. No water. No water as how. Baby. This one starts.
Honey,
Where you know this from? Wait. Like, I'll begin.
My video.
What are you doing here looking like this? What happened to you? That's
My life, I even see the class.
you like this.
What's it your machine?
What happened?
The team I did look.
My mother died. So my mom used to have
yay. See, I never get chance for myself. I can never get time.
okay.
See how it's crash after it. You have not like touch it.
Okay. So today we are going to dwell a lot more both on the partnership now to have a better understanding. We had talked about it before today, and we've discussed all of the vehicles of doing business. And then I told you we are going to be dealing with the legislation. I want to get inside the legislation now and try and understand the form they take, the provision types, and how they affect negotiation or even the relationships of parties that are in business. So, all of them, whether you are involved in sale of goods, is the same. The act has the same component we're discussing today. Whether you are dealing with, you know, with shareholders in a company registered or incorporated, the undergirding legislation, that is the KAMA, Companies and Allies Matter Act. They also contain the provision types we're going to discuss this evening. But what is important is that we need to create some level of awareness for you so that you can have some working understanding how how these provisions work, in what circumstances. You may not know the details in terms of application. You can leave that for the experts. But be that as it may, if you are aware, at least you can reinforce, that will reinforce, your knowledge, the kind of request you are making of your lawyer to bring to your attention, because you know something about these laws affect what you do, and until you are able to exhaust those things, you shouldn't really rest. Now, as we discuss the provision, we relate it to partnership relationships, which is also commonplace. Some of us I know are in partnership as we speak. Some are going to be in partnership. So whichever way, and some have had experiences before. So we are going to participate, all of us. It's not just going to be me talking. And I keep telling you, you must learn how to speak out here or speak up. If you don't speak, you don't know, you won't develop that confidence, and you will not also help others who ordinarily want to speak. So I do not, the host has not made me a co-host, so it will be difficult for me to share my screen. I want to believe that we all have the Partnership Act. It's been with you for quite some time now. So please open it. Open the Partnership Act so that we can at least be on the same page. Because we need to go to the partnership. Now, so when we are dealing with legislation like this one, Partnership Act, that deals with business, and in this case, partnership business, there are three main provision types you will find in this law. So what we want to do is to find out what those provisions are. How do we recognize them? Why are they in the act in the first instance? Okay, and then what is the value for the partners that are involved? Now, the first provision type you find in any legislation relating to business is what you call mandatory provision. Mandatory provision. Again, mandatory provisions. Now, you ask yourself, when you say a provision is mandatory, what is the implication? Mandatory simply to me means that something that binds you, you know, something you must obey. It can be prescriptive, it can be prohibitive, but whichever way, it binds the partners or those that the law applies to. It mandates, it commands, it dictates. So when something commands you, dictates you, binds you, you have to obey it. That is what it simply means. So, and you ask, therefore, knowing the ordinary meaning of mandatory, just like mandatory for, why do they put it in legislation? Now, we find them in legislation because the parties that are in business, they come into that relationship more often than not with different negotiation power. So the power to negotiate among business people are not always the same. They don't they don't often stand on the same pedestal. They stand on different pedestal or levels of relationship. So and it appears or it applies in any social relations. When you are doing something that has a higher bargaining power than you, the possibility is that they will take advantage of that their power at your expense. So there are such cases, and to avoid that type of undermining those they are dealing with, the legislation will put some mandatory provisions into the act to level the field, to provide a level, you know, playing field for the partners. So, and because it is binding, you will not be able to use your power against the other person. And sometimes, it also reduces the cost of negotiation when you mandate people. And then it is, the parties to negotiation recognizes right away that they all have to obey this. So it is no, there's no cost to exact. It's only when there is no, or there is no command, the binding effect that people that has power can exact cost for purpose of doing what they ought to have done. So when it comes from the lawmaker, it reduces the cost of interaction, the cost of negotiation, because on that particular level, we are all on the same. And then secondly, is also to avoid one party taking advantage of the other by using his powers to change things and dictate something else that is not ideal, for everyone. So that is also another, and again, mandatory provisions are also there to standardize, to provide common standard so that everybody has the same understanding and the same impact regarding what is at play. So that is the first part of it. We have identified a provision type to be a mandatory provision. Have also explained why it is often in a legislation this way because of disparity in bargaining power, of those that are in business and relating to one another, who will need to negotiate around a lot of things. So if those provisions are not there, it will be awkward for some why it is free lunch for the other people. Now, so that is the reason. Then the next one is that, okay, now that you know they are in legislation and you know the reason why they are there, at least in part now. The next question is, how do you identify this provision? How? So, okay, you identify a mandatory provision with a word or a phrase because already you know that it is one that mandates. You cannot run away from it. It applies to you, whatever it is. So it binds us. So normally when you read a provision of law and you say the parties shall do so and so, the word shall conveys an idea of dictation. If you shall do it, sometimes you will find must also used, and it is hardly used. Must is hardly used, but has shall, is common to show that yes, you are bound by this one. You can't change it. It attaches to your relationship, and you must take cognizance of it. So don't think about changing it. Okay. So I want us to go to. It's unfortunate that I don't have a sharing capability. Let's see. If I'm made a host, that can change. Let me make that. I've requested that before now, but maybe my colleague forgot. Let me quickly. Mm. So we can go to until I am made a co-host. So you have to rely on your own companies, on your own partnership app. I'm opening my own. I'll be reading from here. So you also read from your own. That's the only way we can do it for now. We can't continue to wait. So as I said, let's look at section 1, for instance. I will read it out and you can follow me. We are looking for examples now for identification. Now, sometimes I have talked the word shallow or must, but sometimes it's as easy as this, as you read the section. A section that is read or that is couched in such a way that it doesn't give you any leverage to turn away from it, to modify it. It's also binding. Now that is another way. Yeah. When it states the position of the law, that is the position. It is not for you to start twisting it. So that is also a means of identification. Just the word is, you know, or the party does, or that the party does not, have the capacity to do something. It shows that you don't, you are not allowed, to do something, extraordinary or different from what you are reading. So so we also have to bear that in mind. So as we go through these examples, look at section 1, I said, section 1, let's see. Then a definition provision, when a provision defines, which means the lawmaker wants or ascribe a meaning to the particular word defined. And once it is their own definition, you cannot create your own definition. So therefore, every definition provision in the Act is binding, is mandatory, or any concept that is being defined in the body of the law is also binding, and it is not for parties to change it, okay? So section 1 says, you can see it says definition of partnership. The lawmaker here is defining partnership for us. It says it is the relation which subsists between persons. That is the first one, between persons. Those are very serious phrases. When it's between persons, which means you cannot be in partnership with yourself. It has to be with others. Persons, that's in plural. So to be a partner or to be in partnership, you must be dealing with at least another person, making total of 2 or more. Okay? And then between persons carrying on a business in common. So those persons must be carrying on a business. It cannot be something else. It has to be a business. It's not just social relations now. In this partnership we are turning with there are different types of partnership. There's social partnership that often leads to marriage, that leads to some relationships. But this one, you must be carrying on business, okay? And then in common with another. It's the same business. Not everybody is involved in the same business, not different types of business. That is why it is in common. And then with a view of profit. The whole objective is for the partners to make money, profit. So if you are in partnership and you are not and you don't intend to make profit, then you are not covered by this law. You have to go and look for your own law. Okay? So two or more people carrying on business in common and then expecting to make profit. That is partnership. So this type of definition under section 1, subsection 1 is a mandatory provision. It is a mandatory provision. And it is important that we bear that in mind. The mandatory provision will bear that in mind. Okay. Now, let us look at section 4. Again, let's look at section 4. You see, you open yours to section 4. Say the meaning of firm. The meaning of firm now, because sometimes you say partnership, sometimes you say you are in a firm, firm of accountants, of auditors, or whatever it is. Sometimes you are in that kind of lawyers and stuff. So a person who have entered into partnership with one another are, for the purpose of the act, called collectively a firm. And the name under which their business is carried on is called the firm name. That is telling us what it is. That is, if you are looking for the definition of a firm, it is there. It is just the name, under which a partnership is described, and the name you use is your firm or partnership name. So bear that in mind. Now, we will take as many examples just for varieties, or So let's look at section 5. The next section. Every partner is an agent. Now, just pay attention to this. The style for this one is this particular section is stating a position that affect the partners. Okay, and so long it doesn't give any of them ability to tamper with this one, it is mandatory, because that is what the legislature is dictating for those parties or those partners to bind them. Every partner is an agent of the firm and his other partners for the purpose of the business of the partnership. And as a result, the acts of every partner who does any act for carrying on in the usual way business in the usual way business of the kind carried on by the firm of which is a member bind the firm and its partners, unless the partner so acting has no authority to act for the firm and in the particular matter, and the person with whom he is dealing either knows that he has no authority or does not know or believe him to be a partner. Now, this section is defining for us a situation that will happen in relation to partners. Now, the first that is telling us is that every partner is an agent of the firm. When you are an agent of your firm, let's say there are 3 persons who are in partnership. Every one of them is an agent of the firm, and they can act for the firm. It's not as if A only can act, B only can act, C only. No, all of you are agents. And it goes on to say that anything you do in the usual way in which your business is carried on, we bind the firm and also bind the partners. So you can see the kind of empowerment, the kind of authority that is being stated. So each of you are agents of one another and your business. And whatever you do, we bind your partners. We also bind your firm, your partnership business. It will bind it. And also, when you deal with a third party, it will also bind except when you are dealing with somebody who knows that you have no authority or who does not even believe you're a partner, then that one cannot say he has a business with your firm if he doesn't know, or if he knows you have no authority. But to the extent he doesn't know and is dealing with you, and you are also you are a partner, and you are projecting yourself to have that authority, it will bind. So that way, it resolves the relationship or the actions of each of the partners to one another and their business, and the action of of any of the partners to third parties who are not privy to their relationship. Okay, so you enter in a particular place, somebody is dealing with you, attending to you. Yes, it's been heard out. Ostensibly, he is a partner and he has the power to deal and relate with you on behalf of his other partners or his business. So this kind of definition of or this kind of provision that is using is just stating what we must know about partners and partnership, and that one binds everybody. The only reason why this one will not, we will see later, particularly in the context of partnership. Okay. Now, we can also look at number 6. Let me check whether my, okay, I still cannot. Now, let's look at number 6. It says an act or instrument relating to the business of the firm and done or executed in the firm's name or in any other manner showing an intention to bind the firm by any person thereto authorized, whether is a partner or not, is binding on the firm and all the partners. So whatever you do, you act, or any business that is relating to the business of your partnership, which has been done or is executed in the name of the firm. So if you are acting in the name of the firm, or you are executing document in the name of the firm, you know, in a manner that is showing that you want it to be, to bind your firm, okay, by anybody that is authorized by that firm, whether the person is a partner or it is not, is binding simply because it is done in the name of the partnership and with an intention that it will bind the, the firm. It will bind. That again is mandatory provision. That again is mandatory provision. I will take 2 more just for purpose of emphasis before I can, after I've taken 1 or 2 more, then I will ask you some questions. We are still on mandatory provision. We are not going to move away from it. But let us look at section 10. Well, that is very important. Well, let us take it from 9. Every partner in a firm is liable jointly with the other partners and severally also for all debts and obligations of the firm incurred while he is a partner. And after his death, his estate is also severally liable in a due course of administration for such debts and obligations so far as they remain unsatisfied. Okay, let us leave it that way. So you can see section 9 is also mandatory. And why is it so? It's telling us the implication of liability as a matter of law. That's why it says that every partner in a firm is liable jointly with the other partners and also severally. What does it mean to be liable, jointly when you are a partner with other people? Which means that everybody, because that liability obligation, is incurred in the name of your business. So there is no separation between the partners and the business. The partner is the business is the partners. Okay, so therefore, liability is joint. And what it means is that the creditors of the partnership can grab one of you and sue you to the extent of the firm's indebtedness if you appear to be the most financially buoyant partner. You collect all this money because it's cheaper to get you. And after he has done that, you can now go to your partners and sue them for contribution in paying for the indebtedness of everybody, and you have a right to. It even goes ahead to show us that even for those who have died, their estate is still liable. Okay? Once there's a letter of administration, you can sue them and get his own contribution before he died because he takes that indebtedness to his grave. And the only way it can be excused is if the other partners forgive him. But at least this is the statement of law. This is the statement of law. Okay? So that is also mandatory. So let us look at section 10. Let us look at section 10. And I want you to also see it's also an example of a mandatory provision, but just follow the pattern. Where by any wrongful act or omission of any partner acting in the ordinary course of business of the firm or with the authority of his co-partner, a loss or injury is caused to any person not being a partner in the firm or any penalty is incurred, the firm is liable, therefore, to the same extent as the partner so acting or omitting to act. So this one is that if you are a partner, since the law says that you are the agent of other, you can act, the other people can act. So if you are doing something on behalf of your firm and you got into anything wrongful, a wrongful act, or you omitted to do something while you are doing those things on behalf of your business or your firm, or with the authority of them that you can go ahead. So, or if there is any loss you incurred, that loss will be attributed to the firm because you are acting on behalf of the firm and on behalf of your partners. So the firm is liable for what you have done wrongly or what you omitted wrongly, just as the other partners are also liable. That is what this is telling us. And that is just what it is. Okay. So we've seen the examples, of this because most of what we are seeing here is talking about, not being a partner, whatever you have done is incurred, the firm is liable. Therefore, that is the key, or the kicker here, that whatever you do or you omit to do while you are acting for your business and for your partner, that partnership is liable for what you have done to the same extent as the other partners so acting. So that is just the meaning of another example of what I call mandatory provisions. Now, I want us to go to another provision type. Another provision type. Okay. Now, this provision type is what I call enabling provision. That is a provision that enables, a provision that empowers, a
Sorry,
provision.
sir. Can I ask a question, sir?
Please go ahead.
All right, sir. Good evening, sir.
Good evening.
So on section 10, I just want to have a better understanding. Is it saying that both the partner and the firm are jointly liable, or like they share the liability, or what? I want to understand, sir.
Okay. When you are talking about joint liability, it's like three of you. But then so anything that is done in the course of carrying on your business as partners, the indebtedness belongs to your business, that is the firm now, and the indebtedness also belongs to the partners. The partners are jointly liable in the sense that they must all look for the money. They are liable to pay for what debt you have incurred. So that is joint liability. But in actual life of enforcement, because the person you are liable to, and it is common sense too, is your creditor. You have collected business, some goods you are yet to pay. There is liability there. And that liability is not for just one person, it's for all the partners. And and when you are talking about all the partners, you are talking about the business itself, which is the firm. That's why, because the law does not separate the business from the owners. The owners is the business, or they are the business is the owner. So there's no separation. So that is why they use the issue of joint liability. Joint liability means that one of you could be sued for all the debts. But if one person is sued for all the debt, the person that is sued can get the other colleagues or partners to come and contribute. If, for instance, there is a 15 million debt and the creditor grabs you, sues you, get judgment, execute his judgment for 15 million. Remember, you are three. So you have paid 15 million. The other two people owe you 10 million. So you can go after them and collect your 10 from them as well, totaling 15. That is what several also means. And that is what joint also means. It is just, an attribution of responsibility to ensure that the debt or your obligations are, you know, are, are carried out. Okay. Now we are moving on to the second type, provision type now, which is enabling provision. Every legislation dealing with businesses amongst the people, must have some empowerment, some enablement, because it is not often, there's always an information or knowledge gap by those who are going to be in business and for which this law will regulate, and also from the standpoint of the people making the law. Except you have been, and that is why when you are doing lawmaking in an area, you need people who have experiences on the field, because you are sitting in Abuja comfortably, legislating on how people do business on the street. If there is a serious knowledge gap, there will be a problem. But what often happens is that there is always a contribution from people who are in the market, who are in the business, who are familiar, so that when they consider provision by provision, they try to mimic, to reflect the true life situation, and by so doing, they incorporate them as an empowering provision that, well, if you get to this point, you may choose to do this, you may choose to do that, or you have an option. So an enabling provision is just a provision that empowers you to take a course of action. It's not binding. This one is not mandatory. When and it's just to give you, some options to go about in the way as you run your life in business. Okay. So, and the way you can identify a, an enabling provision is by the use of the word may. When you say may, meaning that you have a discretion to take this course. You don't have to do, but at least if you want to, you can do it. That is what it means. Now, let us see how it works in real life situation. I want us to read section 17, subsection 1. Section 17, subsection 1. Now, I want someone to read this section 17, subsection 1 and tell us what type of provisions is this. We have done two. At least I've given you the two, two types now. So it can either be one or the other. The third one is coming. So we're given the fact that we have at least done something let's also start warming up with all of these things. So section 17.1, someone to read it and tell us whether it is a mandatory provision or an enabling provision. Quickly. And I don't want people to keep quiet, because if you do keep quiet, then I will also keep quiet, and our class will close very early. Okay? So I want to hear you. Don't be
Let me
afraid
read
whether
that.
you are right or not. Please read. Thank you.
Okay. A person who is admitted as a partner into an existing firm does not thereby become liable to the creditors of the firm for anything done before he became a partner.
Okay. Thank you very much. So is that particular section you read, is it a mandatory provision or an enabling provision?
It is a mandatory provision, sir.
Very good. Why do you say it is?
Because of the phrase does not.
God bless you. Because he is telling, this particular section is telling you that a person that is admitted as a partner into an existing firm does not, that is, you cannot hold him liable, does not thereby become liable to the creditors of the firm for anything done before he became partner or a partner. He's just joining. You have been living your life as partners, and in so doing, you have incurred some indebtedness. And if he's joining today, why are you going to burden him with the indebtedness of 3 years before he came? So this one is like a prescription. Don't keep any debt on this man coming for whatever it is, which means when he joined, he will continue to be, to become liable for his own that is participating, but not before. So you are correct in, that identification. Thank you. Now, so again, I want someone to also read subsection 2 quickly. It is better if another voice is heard, but if there is no voice, yes, the same voice can continue to go. Okay. Subsection 2, read it and let us know how you will classify this. Please quickly.
Okay, I read,
Yeah.
sir.
Subsection 2.
Okay, someone else.
Hello.
Okay, go ahead.
Subsection 2.
Thank
A,
you.
a partner who retires from a firm does not thereby cease to be liable for partnership debts or obligations incurred before his retirement.
Okay. So, well, how do you categorize this one? Or is it mandatory or is it enabling?
It's mandatory, sir.
Why do you say so, my dear?
Okay, because of the words here, it says does not, and I also had a
The-
question from it because why that was even one of the reasons why I read it, because I was finding it difficult. I'm trying to understand why after the person has retired, the person will still be obliged to pay the debts. But if he has retired, does he still get benefits after the retirement? I'm
First
trying
of
to.
all, wait,
Yes, sir.
first of all, understand what you read and don't read anything into it. Once
Okay.
you start reading things into it, beyond what is written there, then you'll be running into trouble.
Okay,
Okay?
sir.
And except we're around you, we will not be able to bill you. Now, a, a partner who retires from a
Yes.
firm does not thereby cease to be liable for partnership debts or obligations incurred before his retirement. Now, this is how it goes. You have been a partner with other people in business for 3 years, right?
Yeah.
And and three of you as a business people incurred a debt of about 10 million. And you say you are tired, please, you want to retire from this partnership, you no longer want to be a partner. What this section is saying is that yes, you can go, but your own quota of the firm's debt follows you, and you will still have to pay that one, whether you want to go or you don't want to go. Does it not make sense? Because if you run
Okay.
away,
Yes.
who are you running away from when you have your own quota? Who is going to pick it up for you? That is what this law is saying,
Oh,
letting you know that you are still liable for those debts that we have incurred for 3 years, even if you retire today. So
okay, sir.
expect us to come and knock at your door for your own contribution. That's just it.
Thank you, sir. I
Okay,
understand better now.
good. Now, let us look at subsection 3. And somebody, and again, I want to thank those that are speaking, and I really like this kind of interaction. This is how people learn better, by also looking at it and participating. You cannot get these things right easily or even understand it if you are not talking, making errors, having confusion, clarifying it for you, then you will be standing still and very steady. So subsection 3, quickly, somebody to read, please.
I have a question, sir.
Subsection 3, sir.
Okay,
Subsection 3.
okay. After the
A,
subsection
a,
3, you can do your question, please. Yes, oh yeah, go
a,
ahead.
yes, sir. A retiring partner may be discharged from any existing liability by an agreement to that effect between himself and the members of the firm as newly constituted and the creditors. And this agreement may be either expressed or inferred as a fact from the course of dealing between the creditors and the firm as newly constituted.
Now, thank you. This particular provision, do you see it as an enabling provision or a mandatory provision?
Is enabling, sir.
Why is that so?
May, because the word may will give repeatedly.
Okay, you are correct, but let me just add some words of explanation. You see, when you read these provisions, again, they are all mimicking what partners experience, and they give us an opportunity to look at it again and see whether if our life is like this is what we can do. And that's why the word may. We are empowered. We are empowered to do this. And what are we supposed to do here? It says a returning partner may be discharged from any existing liabilities, like my friend who asked the subsection 2. Now you are seeing something different from what you saw before. There I say the lawmakers are saying now that if you are retiring, you may be discharged from any existing liabilities by an agreement to that effect. But who is going to get it happen? He said between the person retiring and the members of the father, this his or her colleagues who they have become partners, and of course the newly constituted, okay, and the creditors, because the business owes the creditors, and those that are going to pay are the partners. One person is retiring. This law says that, well, the remaining partners can say, we forgive you, we will take care of your own quota, don't worry. But before that agreement will work, they have to agree with the person leaving and also bring in the creditors, because it's the creditors that are going to be looking at people now, two people instead of three people, as debtors. Okay, so that is what this one means, that this one empowers the remainder of the partners to forgive their colleague who is retiring. But to be able to do so, they must agree. There must be an agreement involving the retiring person and his colleagues and the creditor. That is what it is. So it's an empowerment. So they don't have to forgive, but if they choose to forgive, they can forgive. So they have an option. Because that option is there, we call this provision type an enabling provision. It's a provision that empowers them to forgive one of their own, to forgive one of their own. Now, so you can see from section 6, 7, 9, 8, 9, 10, all of those things that we have been reading out that relates to the partners, defining their rights, their liabilities, and all of their relationship. That is what this provisions is educating us. If we are going to go into partnership, these are the provisions you must be familiar with so that you can assert yourself. You must know basically the intent and the purport of this provision so that you will be able to make meaningful contribution and you will not also be cheated in your own right. So that is that. Now let us look at section 19. Section 19. After this section 19, I will then go to the third provision type. Section
Question,
19,
sir.
somebody should, okay,
Question,
that's
sir.
your question. Quickly,
Yes,
go
sir.
ahead.
Sir, my question is down section 2.
Section what?
2, the one we just read before we read 3 now.
Okay, go
Subsection
ahead.
2. A
Yeah.
partner who retire from a firm does not thereby cease to be liable.
Yeah.
That is, now this one is talking about retirement. In the case of death, what will now happen, sir?
But we showed that we saw that one that says that even the estate will still be liable under section 10. You can, I mean, somebody can die, but if you do, section 10 tells us that that your liability will follow you. That's what we saw in terms of estate. There was a section we read that brought it out for us. I'm trying to get it now. Now look at section 9. Every partner in a firm is liable jointly with other partners and severally also for all debts and obligations of the firm incurred while he is a partner. And after his death, his estate is also severally liable. Are you listening to me now? The
Yes, sir,
guy
I'm
that
listening.
asked a
Yes, sir, I'm
question.
here. Yes, sir, I'm listening, sir.
Yes, I hope you can see that for if he dies, the estate will still remain liable. That's why I brought you back to section 9. Okay?
Thank you, sir.
So
Very clear now.
except they forgive you, you will still be liable, and your estate will still be liable as well. But it is possible for them to let you go, and because your estate, will have an executor, they can agree with them that what you've done so far is okay. We free you, we take care of the rest. Okay. Now I want someone to read section 19 and tell us what you feel about that one.
Okay, sir.
Yes,
Sir, I will read 19, sir. Evening,
go
sir.
ahead, please. Go ahead.
The mutual rights and duties of partners, whether ascertained by agreement or defined by this act, may be varied by the consent of all partners, and such consent may be either expressed or inferred from a course of dealing. So, sir, from my
Okay,
own opinion, is enabling, sir, enabling provision, sir, as a result
okay,
of the word may.
okay. Thank you. Now, what does this mean? We have been seeing for quite some time now, we've been seeing mandatory provision, limited provision, and all of those. Some of the ones we've read before that relates to the parties, indebtedness and all that. This law says that, so, and then you are saying that this one is enabling as well. But what does this section 19 mean to the partners and the partnership? I'm sure you do not understand so much about the implication of this section. So that's why I want to read it again and then explain it for everybody to understand the implication of this particular one. And generally the partnership law. That is to show you that it is not really rigid, flexible. The mutual rights and duties of partners, whether ascertained by agreement or defined by this act, may be varied by the consent of all the partners, and such consent may be either expressed or inferred from a course of dealing. Now, section 19 is telling us that all of what we have been reading that relates to the mutual rights and duties of partners. And there are many that we have seen, there are many that we will still see. This section is telling us that the partners may vary it. And when you say may vary, mean you can change it, you can modify it, but it has to be by consent of all the partners. And such consent may either be express consent, we agree, no, there's no problem, or we are acting it out without necessarily expressing it. So our conduct is consistent with changing it as opposed to writing it and agreeing to it. That is what this section 19 means. So section 19, meaning, this section 19 is indeed a very critical section that allows partners to modify, to mold, to constrict, to extend any of the rights and liabilities or duties that they have here. So if you are owing us, the partners can agree and vary the right we have against you in any way. So this is why we say that partnership law is very flexible, is very negotiable, is changeable, is replaceable. So because of this section 19, it says that all the rights, mutual rights and duties as ascertained by the agreement, whether it is the one that the partners themselves formulate by agreement or the ones that this act has imposed on them, notwithstanding, those rights and duties may be varied. And by what? By the consent of all the partners. So when you say that this particular section is enabling, I told you you are right. But the one you didn't see, and which is not your fault, that this section is both enabling and mandatory. And you see where it is not mandatory. It is mandatory in the sense that to be able to change it, those rights and duties, there must be a consent of all the partner. If you don't get it, you can't change it. It is not about majority, it is about all the partners' consent. So in order for the partners to be able to vary mutual rights and duties, what must happen? All of the partners must agree. They must consent to the variation. They must consent to the modification. They must consent to the replacement. If that is not happening, it will not work. So because there is a condition that will make that variation replacement work well, that hangs as compulsory for all the partners to do. Otherwise, they will not succeed. Okay. So if you change it, for instance, and not everybody consents to it, the person who has not consented will go to court and nullify whatever you have done, because that one binds you and you can't change that condition. Because the only condition for replacement or variation is that everybody must consent to it. That is it. So I hope you understand this thing. Although you may not, it may look as if you understand, but I'm sure by the time you go home over the weekend, you will not even be sure again whether what you had. You might even have forgotten what you are hearing. No. So we leave that and we go to the third provision type, which we call default provision. This one is called default provision. Default provision. Now, what is default provision? Why do we have it in the legislation? And how do we identify a default provision? Okay, that is what we are going to do now. So I will explain default provision by referring to what we do outside law and then bring the same experiences back into law so we can better understand the meaning of default provision because it's a very critical one, and many lawyers don't understand this. Many business people also will not know. They will only know when there is problem. By the time they are confronting it for real, there's already a case in court. Okay? And at the end of the day, the result they will get, they will not like it. And in the end, there may be an everlasting malice. There may be a plan to kill one another or hurt one another just to get the kind of justice they want. And they have to resort to those kind of things because of their ignorance or the ignorance of their lawyers. And at the time they are getting the judgment is painful and they want to take laws into their hand. Now, how do we go about understanding default provisions? And it's really very relatable. You can relate to it because it's something we do ourselves outside of studying law. Now, let us take a class of 100 people and we are giving Samsung telephone new to use and we all open it. Okay? By the time we open the Samsung phone, what we find there is the default setting. To use it, you are confronting the default or factory setting. That factory setting is a take-off setting. That is, to go ahead using this particular telephone, you begin to operate on the factory setting because that is the underlying setting. It is the underlying setting. So when you successfully identify a default provision, there is also what you call an underlying rule. Underlying rule, just as the underlying default factory setting, in phones, on televisions, you are setting up for the first time. Okay, that is the underlying setting. But then remember that as you open the telephone, we are all on the same page, factory setting. But all of us can never like the factory setting. Some of us can't even stand the factory setting. But the good thing is that the manufacturers enables us. The manufacturer has enabled us to change that factory setting in case we don't like it. The same applies to a default provision. Now, whenever you see a default provision, there is always an enablement component that also allows the partners to change that underlying rule in case their circumstances does not fit into the rule. Because it may well be that everybody if you have 100 pockets of partnership, we all come with our different circumstances. Our stories are different one from the other. So we now now the lawmaker now gives us a rule that they call underlying rule, which is to apply to all pockets of 100 partnership. That is what we call a one size fit all. When a one size is going to fit everybody, so many people will be dissatisfied. Which means the underlying rule that comes with a default provision in most cases is not efficient, is not effective, and therefore it has to be changed. The factory setting that comes with our phones that 100 people are going to use, a lot of people will be disenchanted and therefore it cannot be efficient, it cannot create happiness for everybody. So there is the need for that empowerment for the users to change to the next level, change it and customize it. So when they're asking you to change it, you're asking you to customize the telephone. They're asking you to domesticate the telephone. They're asking you to replace the rule or to replace the setting with the setting that you want. It is the same way that applies to a default provision that comes with a set of rules, but telling us that you can change this. There will be a language in the rule that indicates that you may change this rule if you don't like it. Now, the, the, the last part of it, though, is that just as the manufacturer has empowered us to change their own setting to the one we like, many of us will still not change it. But if you don't change from the factory setting, you have no choice than to be bound by the factory setting, because that will be the only way you can run that telephone. If you never change it, even though they have told you to change it, then you are bound. So the one you have not changed, the one you have omitted or failed to change will be the one to bind you. Meanwhile, other colleagues of yours who have changed it, they are in their El Dorado, enjoying the phone the way they want it, while you will stay here, if I regretting and complaining. Or some people are even happy with the default setting because they don't know better and they don't even care. It's only when someone sees it as, this is factory setting. I'm not changing it. I don't know, Jerry. So you can help to change. So the same applies to law. In default provisions, there is an underlying section or an underlying rule. Now that rule is to apply to all business people, all business people. But because all business people may not like the rule, the legislature has given them a way out to domesticate, to change the rule to their own rule. So that is the only opportunity that legislature has given people to make their own law regarding that particular provision. Make your law. But because of ignorance, people don't take advantage of it to make their own law. And when problem now starts and somebody has gone to court, it is too late to change. At that point, they will be bound by the rule they never liked because they refuse to change it when they have opportunity to change. You must change the rule before a problem comes. If a problem comes, once a problem emerges, you cannot change it anymore. You have to be bound by that, and whatever you get out of it, you cannot complain. So that is what default provisions means. It has three components: the underlying rule, the enablement part, and then the need, where there's a failure to change, that underlying rule becomes your mandatory provision. So, and we're going to, the interesting thing is that I'm going to take you to where you have this thing filled out, and every one of us, we are going to participate before we close. Now, let us go to Rule 24, please. Let us switch to Rule 24. Switch to 2024. Then I'm going to read the introduction to you because this is a classic. Section 24 is a classic default provision, and we're going to go over it, how it works. Are we there?
Yes, sir.
Yes, sir.
Okay, good. Now let me read this. The interests of partners in the partnership property and their rights and duties in relation to the partnership shall be determined subject to any agreement expressed or implied between the partners by the following rules. Can you see? This section is telling all partners that their interest in the partnership, property and rights and duties in relation to the partnership shall be determined. Can you see that shall is what? What does that shall tell you? What does this shall tell you? That it is going to be mandatory. That is, those interests, rights, and duties of parties in their relations to the partnership shall be determined subject to the agreement expressed or implied between the partners by the following rules. Now, how do you, I will stop there. How do we identify default provisions? There are some clauses or some phrases. One of the phrases is that except a contrary intention appears, unless a contrary intention appears. That is number one. Number two, unless the parties otherwise agree. Unless the parties otherwise agree. Or unless, are we following? Unless the parties otherwise agree, unless a contrary intention appears. Okay, when you are seeing those phrases, those are the phrases of empowerment to change. That is why when I read this section 24, it says, the interests of partners in the partnership property and their rights and duties in relation to the partnership shall be determined, let us take this one now, by those rights shall be determined by the following rules, subject to any agreement expressed or implied. This phrase, subject to any agreement, meaning that whatever these rules are subject to this agreement you are going to make, express or implied. It is the phrase that empowers you to change what they call the following rules. These are the rules that we call underlying rules, and here we have 9 of them. 9 of them. But the good thing is that you have been empowered to change these rules by this phrase, subject to any agreement expressed or implied between the partners. Which means the partners can decide to consider this rule, retain them if they are okay, change the ones they think they are not okay to the one they will like. That is what it is. So what we are going to therefore do is that now that, because if we don't change this rule, the rules will bind us and we have to live by it whether we like it or not. But if we are prospective enough and we are smart enough and we recognize, we are aware that we have an empowerment to change this rule, if we don't like it, it is now left in our court to change it. So there is no point to complain. Let us change it before it becomes too late. And so that when we start our partnership, we start on a good, loving, template. That is what it is. So since we have been told that these rules are the one that will regulate the partner's rights and duties in relation to the partnership, subject to whether or not we want to change it now by our agreement. So let us take this rule. We are going to take these rules one by one. Those who have not spoken, those who have spoken, we will take it one by one. First of all, you will read the first rule, whoever is going to go for it. Then after having read it, the question is that the class is now asking is that should the partners change this rule? If you say yes, you tell us why you think they should change it. If you read it and you think the partners can live with this one, it's a good rule, they should leave it. You tell us why it is, and we move on to the next one. We will do it from 1 to 9, and then by the time we are getting it done, there will be some joy and some happiness that at least we are taking something home. Okay, rule number 1, somebody to read it.
Rule number 1,
Okay, go ahead, sir.
all the parties are entitled to share equally in the capital and profits of the business and must contribute equally towards the losses, whether of capital or otherwise sustained by the firm.
Now, the question to you is that should the partners change this rule?
No, the partners should not change the rule. because
Okay.
it's okay for the profits to be shared equally and the losses.
It is okay to be for the profit to be shared equally
Equally.
as well as the losses.
Yes.
Okay. Any
Losses, yes.
other contribution? Thank you.
Yeah, I think it's possible to change the rules, sir.
Why do you say that?
Depending on if one or two partners have extra responsibilities, then they might as well get a higher share of the profits.
But what do you mean by higher responsibility? Can you clear so that your colleagues can understand?
So, for example, they might be bringing in more money, more capital, and
Okay.
they might also be maybe managing partners or something.
Now, okay. Now, I think, yes, is there any other person? But thank you. I'm going to come back to your contribution and the other person too. But I want to take one more before I explain it. Yes, but I'm happy about the responses I'm getting already. Any other contribution? Should the parties change it or they should leave it? Okay.
They should leave
Now,
it, sir.
huh?
They should leave it.
Okay, thank you. Thank you. Now, I will take it from where the second person came in. You see, this rule is talking about sharing profit and capital and losses. He's not talking about contribution. He's talking about sharing equally in the capital and profit and then the losses. He has not talked about contribution of the partner. So if there are three partners and they contributed 30 million to their business, overall, one person contributed 15 million, another one 10, the last person 5 million. Sorry, yes, 5 million, making 30. That is their contribution to the business. And they have now made, let us even say, they made 15 million in the year. This law says that they will share the profit equally and the losses equally as well. But they did not contribute equally. Somebody contributed 15 million, another 10, another 5. So I will ask you again, for those who said we should leave it, is it fair to leave it or it is fair to change it?
Fair to change it.
Please, sir.
Huh?
Good, sir.
Fair to change it. It's fair to change it.
Okay, it is fair to change it. The reason why it is fair to change it is because if you do not allow sharing formula to follow the rate of contribution, some people will end up being very angry. Now, if I imagine after making 15 million, the person that contribute 5 million now writes to the partnership that we thank God for his message for a bumper year, making 15 million at our first year. Please kindly see my account details and send to me my own quota of 5 million for my, as my own entitlement. He writes it and is the one that contribute least. He wants to share 5 million, 5 million with the other rest. So, he wants equal sharing, which is what this law is saying. And it is going to be 5 million. And yet he contributed 5 million. Somebody who contributed 15 million is also going to be taking 5 million. The person that contributed 10 million will also going to be taking 5 million. Is that fair? Is that a fair sharing formula?
No, sir.
No, sir,
No,
it's not
No, sir.
fair.
It's not.
Okay, now some of these things happen in real life. So by the time the profit has come, those who contribute, the guy that contributed least is insisting that he must take equally with everybody. It does not matter whether his own is 1 kobo, because the law says it has to be equal, and it has to be equal. And he has gone to court. and the partners have not changed it. And at the end of the day, he's going to win because the law says change it if you don't want it. But if you have not changed it, that law of equal sharing will bind you. And this is where partners kill one another. We are going to show him, don't worry. We are going to show his family, don't worry. Sometimes it's not even the partner alone that will be hurt or be killed. It will extend to his own family because of unfairness and ignorance. The partners don't know this kind of issue. They can tamper with it. They left it. It, had the, it and and again, the guy that is playing mischief maybe has gone to somewhere and they have told him that don't let them know. When the profit comes, just let me know. You have an equal right, and he will be happy. And he's exercising that right now, while the other ones are very angry. And he does not. They will talk to him, he will not listen because he know the law is on his side. But when the law is on his side, what would the other two people do? They will take the law to their own side too and let him show or see why he shouldn't be greedy. So that is why it is important that this particular one should be changed so that it can reflect, and that change that will happen will be the one that reflects the percentages of contribution so that when they are sharing profit or losses, it should also track percentages of contribution. That is what is fair. So rule number 2, somebody should read it. Quickly, our time is running out.
Rule number 2.
Yeah.
The firm must indemnify every partner in respect of payments made and personal liabilities incurred by him. Subsection A, in the ordinary and proper conduct of the business of the firm, or B, in or about anything necessarily done for the preservation of the business or property of the firm.
Okay. That rule, should the parties change it or they should retain it?
They should retain it, sir.
He should
Why?
retain it.
I think they should retain it.
Because if as a partner you go and take a loan, for example, on behalf of the business, when the business is okay, you are entitled to, they should refund your money. So with that, you can be able to stand on behalf of the business. So this law should be retained, sir.
Okay. Now, okay, it is fair, but I want you to, because you have to really think like business persons here now as partners. Don't don't take this one for just for just exam alone. Put yourself as the partner. It says the firm must indemnify every partner in respect of payments made and personal liabilities incurred by him. So whatever I have made payments or payments I've made for our business and whatever personal liabilities I have incurred because of our business, the law says that in the ordinary and proper conduct of the business, that I should be indemnified, and that in and about anything necessarily done for the preservation of the business or property of the firm, I should also be indemnified. That is fair. So which means I have acted for the firm, I have incurred some losses, I have made some payments, and the partner is told, or the partnership is told, that they should indemnify me so that since I have done it on behalf of our business. So I agree with that one. But some people will say, well, it depends. It depends. Am I, why am I paying for if the money I've paid, for instance, is huge, like I've paid 10 million for the partnership, am I going to, will I not take some interest rate on it? That indemnity must, why can't we accommodate me with a particular percentage for loss of my own money for my own business, and yet I have spent it on partner's business? So depending on your creativity, you can say we leave it, or if you are generous, you can say, okay, we can tamper with it a little bit to be more realistic and face the market, because money in the market is expensive, and it goes with certain things, or it's not free. Okay. So because there is always a cost to capital. So number 3, Somebody to take number 3, please. And thank you for those who have made contribution. Number 3.
Hello.
Yes,
Three. It says
go ahead.
a partner making for the purpose of the partnership any actual payments or advance beyond the amount of capital which he has agreed to subscribe is entitled to interest at the rate of 5% per annum from the date of the payment or advance.
Very good. So are they should the partners change this or not?
Yes, I think they should adjust it.
How?
I think that the rate of interest should just be tuned to inflation, should be fashioned according to inflationary rate. So it shouldn't just be less than 5% per annum. So it should flow with
Okay.
the tide of
Okay. Thank you. Any other view? Should
Yes,
they
sir.
change it? Yes, go ahead.
Yes, sir. So I think they should change it. Reason being that now the partner, it's not stated here how much the capital the partner is introducing. So if we are capping it at 5%, the money can actually be lesser or higher. So I think it should be changed, probably in a way that may reflect, the like the interest would be in relation to how much capital or the capital that is being introduced in advance or something like that. But just 5% is somehow, because what if the partner introduced like a higher amount and then it's still at 5%? That's what I
Okay.
think.
Okay, thank you. Thank you. I guess the two the two contributions really reflect the market. It is the reality of the market. Because what he's saying is that we all have agreed to contribute 5 million, and I have contributed my own. Then the partner now goes ahead to contribute more, like 10 million, that is 5 million extra. Okay, and this law is saying that, well, you will be entitled to 5% per annum. Meanwhile, when you go to bank to go and take a loan, they let you know that it's 25% or 26. So, and they are putting just 5% here. So clearly, this particular percentage is very, very unrealistic. It is contrary to what is the going rate at the market, and as a result, there should be, the partnership to change it to reflect as closely as possible to what is obtainable in the market. Maybe it may not track the exact percentage at the bank rate, but at least if the bank rate is 27, you can take 25 or in fact between 20 to 25%. That will be ideal because it is business and it is money. Okay. So number 4, quickly.
A partner is not entitled before the ascertainment of profits to interest on the capital subscribed by him.
So should they change this particular rule or it is fair?
It is fair
Why?
because there's no guarantee that the profit will be recorded at the end of the business year.
Okay. There's no, okay, yes, that is sensible. I agree. Any other person that at least let us determine profit first, because all the expenditure that we have made, the tax payment, we are still going to pay tax, and all of those things we have to do. Until then, the issue of interest doesn't come first. So it is only when there is excessive that we can really declare for one another. I think that is fair. So I agree with you. Thank you. Number 5, somebody to take that.
Number 5,
Go
every
ahead.
partner, every partner may take part in the management of the partnership business. So I feel sad that they should retain it because it's because of that word may. So because there could be some dormant partners, could be some active partners. So some may take place, some may not take place,
So,
some may
so do
not
you
take
think they
part.
should
Sorry.
change? Do you think they should
No,
change
they
that
should retain
particular
it.
rule?
They should. No, I feel they should retain it because of the word may.
No, it is not now. No, we have gone through. Sorry, we are beyond May now. We are now applying law. We know that May is empowering, but we are applying it to the market now, real life partnership life. That okay, you that have just contributed now, you are saying you are one of three partners of a business, and this law is saying that every one of you can be part of manager. I mean, can take part in management of the partnership business. So there will be three managers. Do you think it is rowdy? Do you think there could be rancor and argument? Do you think it is ideal? That is what we are now dealing with. Should the partner change it to something else
Okay,
in
sir.
terms of that is what we are dealing with now?
It should be changed, sir.
Okay,
To what?
To
okay,
be
it should be
changed.
changed. It should be changed. It should be
To
changed.
it should be changed
Yeah. Well,
And to
so
what? Give us
to
idea.
to
I
allow
think
to
One
allow
one. No,
those.
wait. One by one now. Yeah, now. I
Okay, I
heard.
believe I believe it should be changed, sir.
I
If
heard. To what? What are
okay,
they changing it to?
to a better arrangement that will allow those with technical know-how to manage the organization, and not just
Okay.
everybody should just be at top of the management, so that we don't take every Dick and Harry as a manager and we run the company down, sir.
Okay. That is yes. I agree. Then another person.
Yes,
Another.
sir, it should be changed so that there will be
Okay.
delegation of authority, sir.
Okay. Anybody else? You see the danger.
It should be changed, and the partners should agree on at least one person to be an active partner or manager.
Okay. Okay. Now it should be changed. I agree. Just for orderliness to reign. And but then those changes now depends on our experiences in business, because it is okay to say one person be in charge. If we are not careful, that one person must have fed himself to stupor before we realize what is going on. So sometimes when we say we need a commander, like a managing partner, you must also change it in such a way that every quarter he must come back to the partnership to account, to ask questions. I mean, to answer our questions, to bring transparency. Where are the papers? What have you spent? Where are the stocks? Where are the receipts? So that before it gets too late, if at the second quarter you have found one thing, then again we will change you. Are you following? So when you say it should be changed, you must have to know why you are changing, and if you are changing it, into what. And there may be some partnership that is big, and there is, there is a technical know-how that requires somebody. If that expertise is within the partner, that one can be managing technical matters. Issue of logistics, if it is needed in our own company and you have I'm a logistic expert, that one could also be involved as a manager of logistics, and then the coordinator of technical and logistics and funds and everything, that one can also be there. So it depends on the nature of our partnership, how big, how complex it is. That is what we must decide when we are changing or we are retaining. The question is that does it reflect the position of the partnership, the complexity of the partnership? And if it is not as complex and we need just one person, are we changing it and introducing monitoring, accountability, transparency, so that the man does not become too comfortable and start punishing the partnership business for his own benefit. Those are the things I want you to look at when you have an opportunity to change a law like this, being a default partner, because you are domesticating it, you are adopting it to fit your circumstances. The question is that what is your circumstances? You must think about those circumstances of people living the life of partnership and facing it rough or smooth out there, so that you understand the areas that are very rough and then how you can smoothen it. That is how these things are done. So number 6, please. So you can see, you
Number
guys
six,
are
sir.
interpreting, this law now as lawyers, providing solutions and everything. That is how it should be. Number 6, go ahead, my dear.
Yeah, number 6. No partner shall be entitled to remuneration for acting in the partnership business. This should be changed, sir. So,
You are so fast. Why?
okay. No partner shall be entitled to remuneration for acting in the partnership business.
Yes.
So this
So
should
what
be
do you say?
changed.
To what?
This should be changed.
Why?
Because to be changed so that we have partners that will get remuneration, like the active partner that is running the business should be paid for that service or duty.
Very good. Very good. Yes. You see, just as I taught you before when we are doing agency, and when I was dealing with agency. Now, when you deploy an agent, I told you you must have the capacity to monitor. You must have a good reward system. That is, payment system remuneration must be good, and you must also induce what I call bonding cost. So if you have just one partner, okay, if you have just one partner that is running this show for you as a managing partner and you are not paying him, he's going to pay himself. He's going to pay himself, whether you like it or not. And even that you are paying him doesn't mean that he will still not pay himself, but at least you do not be serious. So, because if your monitoring is good, you will also tie his hand. So you must also show that you understand the connection between monitoring and accountability. So, and you must also understand, you know, his status as the agent running this whole thing for you, and the reward. Pay him well, otherwise we steal everything before you know. So I agree that it has to be changed. You motivate him by good remuneration so that he can do much better for the partnership. But of course, when you are doing that, also monitor, include all of that in your own agreement. Formulate every monitoring framework. You must supervisory framework. Put everything out there so that it also knows that in 3 months' time is coming to account to the house. And then, if you find that it's not doing well, then you start looking for how somebody else should replace him and stuff like that. So that is just, I agree that it should be changed. Okay, so number 7, please.
No person, no person may be introduced as a partner without the consent of all existing partners. I think this also should stay.
Okay,
Yes,
why
sir.
do you think it should stay?
So as to prevent issues or chaos, and it also show transparency, because the whole purpose of partnership, having some people being a part of the partner and others do not know, is going to cause issue or rapport. When they get to find out, they may feel that something is going on which they are not aware. Imagine the profit of the company being shared amongst more than the required number of partners they already know. They'll start asking, so when did this person come in, what's happening? And so it will cause issues and all of that. So
Okay, I
yeah.
I also agree. When you are bringing in new person, everybody must be part of, yes or no. It is not even majority. It's just, you cannot say, well, two of us decided you should join us. Why the third party is not? You have to go and challenge these things, because That is the beginning of problem. Once a majority is formulating things, the problem is brewing somewhere and it's going to create problem. So this kind of clause should stay. There is no need to change it. It is open, everybody is participating, there is consent, and everybody is happy. And if one person say, I'm not comfortable, that person goes, you look for another person. So number 8. Number 8. Yes, 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 number 8.
Any differences arising as to ordinary matters connected with the partnership business may be decided by a majority of the partners, but no change may be made in the nature of the partnership business without the consent of all existing partners. I think
Yes.
this should be retained
Okay. What is your reason?
because if there is a, like what they normally say, majority should carry the day. If there are 3 partners and 2 agree that there shall be a change, the other should be binding on all the 3 of them. But no one should just take decision without the rest. My submission, sir.
Okay.
It's like all those
Okay.
people
Yeah.
dey money.
Any other person?
So the person now is it
Now,
he
the
doesn't know
the
his left from
the reason why somebody is talking there, the reason why I agree that it should stay is that
the man
when it
said,
relates to ordinary matters, majority can decide it. But when it goes to the nature of our partnership, everybody must consent. So that kind of rule is okay, and I agree with you that it should stay. Now, number 10, please, number 9, please. There is still somebody that is disturbing of now. Somebody is talking somehow, anyhow here. Please mute yourself. We're almost done. Number 9, yes, somebody to take that. Number 9. If there is nobody, we are going to close it. I will not do it. So I will leave that for you guys.
Number 9, sir.
But yes, go ahead.
The partnership book are to be kept at the place of business of the partnership or the principal place if there is more than one. And every partner may, when it thinks fit, have access to inspect or copy any of them. I feel this should stay.
Okay.
In order for transparency and
Access
so that
to information.
access to documents of the organization, so that when they need it, they can have access to it again. Yeah.
You see, if you have been a member of, you are a partner of a business before, some of your partners that you are working, they will just pack everything. You won't even see anything about business records. Is in their house. They have removed everything. You have to be fighting for all these things. So that is why this kind of situation is always very sensitive. Information access and stuff. You know, even your banking records, you will never see it if you are not careful. So anyway, that is it. I'm happy that we are all participated. This section 24 is a typical uh, default rule, and we have seen now the importance of default rule and how we can engage it, where we recognize that in real life situation, some of these rules may create problem, we change it. And if people now come to you to advise, you are in partnership, you already know the sticky areas and stuff like that. Even when you are going to a lawyer, you will be asking for a lawyer, I want those default rules because those ones are very important. Bring them out for me. You are lucky if your lawyer knows everything, or all these rules, and then you will have better advice, very, 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 very efficient, very, very positive agreement that makes everybody happy because you will get proper advice. So that is how it is. Well, I am very happy that we're able to make up what we couldn't do on Wednesday. And I want to thank you for your support. And for those who have contributed, I really love all of you because you've made the class work. You also make my job a little bit much easier. You do the talking, the reasoning too. Mine is just to direct, just to supplement your ideas. And that is how it is done. So on that note, I will be wishing you a very wonderful night and the very best of the rest of your weekend. Thank you very much.
And you too.
Thank
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 you
you,
you.
very much,
sir.
sir.
Thank
We
you,
appreciate
sir.
So
you.
it is
Love you.
also
Thank you
possible.
very
Thank you
much,
very
sir.
much, sir.
At the best,
Thank you,
sir.
sir.
Thank you very
Yeah,
much. Okay, sir. Good night.
At the end of
it
the
is
semester
also
now, they'll be able to
possible.
call us the law.
Yes, it's also possible that some of my other colleagues will be coming from next week. So if we don't see again, we will be seen in the examination. All the best, anyways. Bye bye.
Thank you, sir.
Oh, thank you, sir. Bye bye, sir.
Thank
Thank you,
you.
Prof.
Yeah, yeah.
Good night, sir.
Good
Good
night.
night, sir.
Good night. Good night.
good night, sir.
Good
Good
night, sir.
night. Look,
mm, 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 mm.